Welcome to Securing Your Brand with SecureMark Legal. On this podcast, we break down the legal side of branding and protecting your business without the legalese. From trademark, copyright, and contracting tips to real-world case studies, we're here to help you safeguard your business, your brand, and reputation. We are here to help entrepreneurs, creatives, and business owners protect what they've built through smart, strategic IP solutions.
Hello, I am Holly McFall, a trademark attorney. Welcome back to Securing Your Brand with SecureMark Legal, where we make legal stuff, especially brand protection and small pivots, way less scary and way more actionable.
And I'm Melissa Jetta, and today we're talking about rebranding after infringement. What happens when a business is forced to change its name, its brand, its logo, its slogan, and how do you do that without losing your customers?
Rebranding after infringement can feel overwhelming. It's emotional, it's disruptive, and it often comes at a moment when a business is already under stress. But when handled correctly, it doesn't have to derail your growth.
And I'm Chelsea Reynolds, here to ask so how do you change your name without confusing everybody? Questions.
We'll walk through that. The rebrand, when it becomes necessary, how do you plan it strategically? How do you protect your trust and the momentum while you're pivoting?
How do businesses usually realize they have to rebrand? Is it after a legal threat?
Normally after some type of legal threat, but businesses that launched without a trademark might proactively rebrand if they become aware of a risk. Usually a rebrand is by force, due to receiving a cease and desist letter or worse, a court order forcing the change.
Though it does often start with a legal notice, sometimes the business does catch the conflict early and say, okay, we need to pivot. We need to rebrand before all of this escalates. The key is recognizing that you have to rebrand and making it a strategic move, not just a reactionary move.
And most importantly, it's not ignoring an infringement letter. Cost and exposure will just increase. And knowing a forced rebrand does not mean the business has failed.
When a business has to change its name or branding, what should they focus on protecting first?
So depending upon why they're rebranding, what is the cause? If it's the name, the logo, the slogan, you want to prioritize the rest of the elements that isn't the cause of the rebrand. So that way you can move beyond it. You can move beyond that reasoning of what was the forced rebrand and work through what is the points, what is your customers recognize about your business. Sometimes you have to do this in the matter of what is in a settlement or per your legal agreement. And then you want to launch and coordinate that launch with the new elements, the new logo, the new domains. They should all be at the same time. So your messaging stays consistent.
You need to make sure you conduct a comprehensive search and file a trademark for this new launch before public rollout.
Rebranding can be more about design and identity management than it is about what is this rebrand, why is the purpose of it. If you're controlling the tone, you're expanding your business, you have a new look, a new identity, but you have to make sure you're, keeping your same customer service, the same reasoning that the customers come to you for your product or goods. You're preserving that reputation.
I can think of a brand or two that had a new launch and I didn't even think this could be because of infringement.
Focus on continuity. Customers don't need to relearn who you are, just what you're called. Keeping your voice, values, and service consistent helps preserve trust during the transition.
What's the biggest mistake businesses make when rebranding after infringement?
The key points are customers don't need your drama or legal details, just clarity. Consistent messaging reduces confusion. Timing matters. Avoid rolling out changes piecemeal. Internal teams in your organization should be aligned before the launch. And a strong rollout plan prevents speculation and rumors.
If your drama is not public, don't make it public. If it is public, there is awareness of the fact that you have to rebrand or there was an infringement of some sort, don't go silent. Don't be vague. Customers don't need to understand exactly what's happening, but what they don't understand, they're going to kind of fill in the gaps themselves, and that could cause a customer service problem. So be clear, be confident, keep your communication open, focus on your business, not the dispute.
So for a positive spin, if we focus on growth instead of why things are changing, that would be a good way to I guess, spin a rebrand.
Exactly.
What legal steps should businesses take to make sure their rebrand actually sticks and they don't have to do it again?
That's really a great question. It really is about a trademark search, making sure that your new name, your new identity, whatever it is that had to change, your logo, your slogan, even some of the old ones, you want to run a trademark search. Make sure there is no infringement going on to another brand. You want to secure your social handles and your domain name. That does not give you ownership. As we know, the only way to have ownership of your brand name, your logos, your slogans, your brand identity is to have a trademark on that brand identity elements. So you also want to make sure you legally change. Once you've done a trademark search, you know you can have this new brand. You want to make sure you change your contracts, your bank accounts, your licensing, your regulations, your registrations. All of that has to be part of your change. It's not just one element you're necessarily changing, especially if it's the whole brand name that's changing. So you want to coordinate from legal. I've cleared this. I'm in good standing. Your marketing and your operation. It all has the same kind of consistent flow. The other important part here is you want to make sure that you're monitoring. You're making sure that for whatever reason you had the infringement, whatever caused the change, you've gotten rid of the product, you've timely changed your domain names, whatever were the requirements inside of that settlement, you're working towards fulfilling those deadlines, making sure you meet them and you don't breach the new settlement agreement in this whole process. It's not just one single step that you legally want to do, but most importantly, you want to make sure you have and control that new brand name.
You mentioned a bunch of different things that were trademarkable. Do you have to have a different trademark for the logo, the name, the slogan? All of those different things need a different trademark.
Exactly, Chelsea. That's exactly what it is. Everything has to have a different trademark registration. Your name, your logo, your brand, all those require trademark registrations. And so all of those can be infringed upon. You can infringe on someone else, or worse, you could be infringing and responsible to them for money, your damages, your profits. All of that can be part of enforcement for a trademark infringement.
So the new brand should be cleared, protected, and used consistently from day one. That includes filing for trademark protection early so the business doesn't end up in the same situation again.
So basically, you're turning this forced rebrand into an opportunity.
Yes, exactly. It's an opportunity for growth. Rebrands can modernize outdated identities. They can clarify positioning and audience. A pivot can strengthen long-term protection. Many successful brands rebranded early on in their growth. The goal is resilience, not perfection. Strong brands are adaptable brands.
Can a forced rebrand actually be a good thing for a company?
Yeah, absolutely. It can be, especially when done intentionally and the rebrand is done and you're protecting everything along the way. You're sharpening your message, you're improving your protection, you're planning now for long-term growth. A lot of entrepreneurs start and they're like, okay, this is my baby. This is what I'm going to go with, but they don't expect the growth that's going to happen. So sometimes a rebrand, though it's forced, it's the kick that moves you along. It actually can be a good thing. Let's wrap this up. Certain things that we need to make sure we do. We don't ignore cease and desist letters. We confirm that we're legally required to rebrand. Just because you got a cease and desist letter, maybe they were wrong. Sometimes we file a deck action, and that can go back to courts in a whole nother flip of the coin. That's a different episode, though. Don't ignore, confirm the rebrand is required, identify the elements that are beyond what is needed for rebranding that your customers recognize your brand for. Clear and protection moving forward, comprehensive search, trademarks, all of that is important to make sure that you can continue to move forward. Monitor the old, monitor the new to make sure that everything is working together and you're fulfilling all of your timelines.
A smart rebrand protects your future. When you pivot with intention, you can keep your customers and your momentum intact.
Thank you for joining us at Securing Your Brand with SecureMark Legal. We're here to help you navigate whether you're forced to rebrand or maybe someone is infringing on you. You can find more information about us on our website, securemarklegal.com.
We have resources to help you pivot confidently and protect what you're building next.
Be sure to like, leave a review, ask us questions. We're here for you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.